share today is going to be California specific, but I know that we could have folks from all over the country, so I will try to go broader as well when I can. Just a reminder that none of this is legal advice that creates a attorney-client relationship here. We're just giving general information. Okay, so hopefully that's helpful. Also, one of the things that I wanted to make sure that I recommend right off the bat, especially because I'm only licensed in California and many of you might not be here, is that there is a great resource online to find a local lawyer who is queer friendly. There's something called the Family Law Institute, or FLI, that is run through the National LGBTQ Bar Association and the National Center for Lesbian Rights, and they are vetted, queer competent lawyers who specifically work with LGBTQ families. And they have a listing by state online. If you just, do a Google search for Family Law Institute, it should pop up. And you can search by state for a lawyer in your state. Okay. I was gonna ask people to raise hands, but most people have cameras off. I think you all can raise hands electronically. If I can get a sense of like how many people here are already parents. Okay, so we got a good number. All right, so it's looking like a lot of folks. All right, I guess you guys can put your hands down. And then how many of you are hoping to become parents? So working on that, but not parents yet. Okay. And then can I get a sense, if you can put your hands back down, please? A sense of how many of you yourselves or your children identify as trans, if you're comfortable sharing that, or if you're here for, a family member who identifies as trans and information for that person. Okay, so we got quite a lot. Okay, so that's really helpful. Thank you all so much. I appreciate you answering those questions for me. So the way that I'm going to go in terms of how I'm going to go through things today is I'm going to go through what I think is sort of the most urgent thing to discuss first. And then I'm going to go for the most commonly asked questions, and then I'll go sort of through my list. I'm going to try to actually speak fairly quickly because I want to make sure there's plenty of time for Q&A. I think there's going to be a lot of that. Maria, I'm going to ignore the Q&A just to try to focus and stay present because there's a lot of boxes here and I feel like there's going to be a lot happening in the chat.
I will track the chat.
Thank you. Appreciate it. So the most urgent thing that I want to put forth as, if you identify as trans or the parent of a child who identifies as trans and you have identity documents that do not match your gender identity, if you have ID docs that you have not updated yet, particularly federal documents, now is the time to get those updated. So your passport, your social security card.
Is a network switch underneath there that those two?
It does.
Oh.
Done by Derek, but
yeah. I got it.
Amira,
Thank you. Appreciate that. So if you have a passport, a social security card, even a consular report of birth abroad, those are all federal ID documents that can be updated to reflect your gender identity at this point in time. And right now, passports and social security cards do not require a court order of gender change or even evidence of medical change of any sort to get them updated to the identity that feels right for you. So for passport, you can choose M, F, or X. For social security, you can choose M or F. And all you have to do is check the box that works for you. That's all it is you apply for a new passport, you apply for a new social security card, and you check that box and you get the new card. For social security, if you go down with the form that you need to fill out and your identity documents, so you'll need to bring like a copy of your passport or something like that, they will make that change on the spot for you. I think it goes into effect within 24 hours if you go in person to the Social Security office. For the passport, I'm recommending that folks pay the $60 expediting fee at this point. The expediting fee should get the passport back to you in 2 to 3 weeks. So those can all still be done now before the new administration. I think that is the one thing that we very well could see on day one of the new administration is removing the ability to update federal ID documents to to acknowledge your gender identity. So even if you haven't legally updated your name yet, you can always do a name change later. I cannot imagine that the federal government is going to say nobody can change their names on their IDs anymore, because people change their names for many reasons that are not gender related, and they're not going to be able to tease that out. So I think name changes will be able to be done in the future, but I think that gender changes very well could stop very soon into the new administration on federal ID documents. So that's sort of, I want to put that up there in the front as the most pressing matter that I'm really encouraging folks to take care of right away. Okay. I think also there are a lot of questions about whether an X gender marker is safe right now. And that's really a personal question that you have to ask yourself based on the reality of where you live and where you may be going and where that may be disclosed, right? And your ID, if it's a state ID or your photo ID, is used when you get into bars, it's used when you're traveling, it's used in all kinds of different places. And obviously it outs you if it says X on there. And so you have to know yourself, and if it's a child, know your child's comfort, and are they going to be ready to deal with the questions that may come out of that potential harassment or discrimination. Of course, I'd love for everybody to have the ID doc that feels right and affirming to them, but for some people, right and safe might mean an ID doc that has an M or an F under the current world that we live in. So, I can't guarantee safety. All I can tell you is you have this option and you have to choose based on your own experience what makes sense for you. Okay. So that's sort of like the most urgent thing. The next question that we get the most often are questions about marriage. Should I marry my partner immediately? Should I, am I going to lose the marriage that I already have? Those are kind of the biggies that we hear a lot of. In terms of should I get married right away? Marriage comes with a huge number of rights and benefits and obligations. Marriage is not just a piece of paper. It automatically changes things in California, like community property rights. There are death benefit rights under social security. There are tax implications. There are a lot of different things that happen when a person gets married. And for many of us on this call who've been divorced, it is challenge to get divorced. It's not an easy process, emotionally or logistically. So I am not somebody who encourages people to rush to the altar if you haven't really thought it through. If you're already engaged and you had the marriage, the wedding date on the books, and you feel better going downtown and getting the license and getting, signing it now, fine, by all means. But if you're sort of with somebody new and you're not really sure and you're really just feeling anxious, that is not when I would recommend that people immediately run to get married. The other thing to keep in mind is that we're not going to lose marriage on January 20th. I don't know that we're going to lose marriage equality at all, right? It could be that that stays in place and that that's not an issue. And if it does become an issue, then I think that it's not gonna happen overnight. It's gonna have to go through our court system. It's gonna have to wind its way all the way to the Supreme Court. Those things don't happen quickly, and they don't happen without warning. We'll know if there is a case that's on the docket where that could potentially happen. And even if that does happen, we also have a new federal law in effect called the Respect for Marriage Act that says that same-sex marriages have to be recognized under the federal government and across state lines. So we have some safeguards in place there. Now, as far as your pre-existing marriage, if you are already married, as long as your marriage was valid when you entered into it, that marriage will not get overturned. It would be a massive change to historical law that we've had in place for the entirety of the history of same-sex marriage. So I feel pretty confident in saying that. Even when we had that window in California where people would go to San Francisco and get married, and then Prop 8 came and took away marriage equality, the marriages during that window before Prop 8 were still valid and binding marriages. There has been general case law that says if your marriage was valid at the time that you entered into it, it will still be valid and recognized. So you don't have to worry about remarrying the person that you're already marrying or doing more. In fact, if you remarry the person you're already married to, it can get confusing for date of marriage for purposes of things of like community property rights and things like that. So we don't have to do it more than once. We don't have to double bag it, so to speak, once is just fine. And we don't have to worry about, the marriages that we already have necessarily being overturned. So those are sort of the big questions that we get about marriage. But I think there's a lot of us on here who are parents, and I want to speak to parentage rights. I'm a family formation lawyer. Most of what I do in my practice is make sure that your parental rights are recognized and protected. So for parentage, it is absolutely essential that you get a judgment that legally recognizes who the parents of this child are, or if it's a single parent, who the single parent is. I mean, as a single parent, we'll talk about that in a moment, but especially for two-parent families, or in California, we can even have more than two-parent families, we want a judgment that legally recognizes the parents of the child. That is different and distinct from a birth certificate. Lots of people can go on the birth certificate at the time of birth, but there's something in the US Constitution called the full faith and credit clause. And the full faith and credit clause says that judgments from one state have to be legally recognized in every other state in the country. A birth certificate is not a judgment. It's an administrative document that gets filled out at the hospital by a birth clerk based on whatever information the person who's giving birth gives to them. And that then just gets processed and made into a birth certificate. Birth certificates can be overturned, they can be changed, they can be amended. Judgments have much more limited abilities to amend, and judgments are what are required to be legally recognized across state lines. So especially for parents who are in California, if you're married at the time of birth, you will both go on the birth certificate. That's kind of the default in California. So you will have that. And in the state of California, you will both legally be presumed as parents and generally protected. So when we get that judgment, what we're doing is we're protecting ourselves going across state lines. So the question I just saw pop up of, is that an adoption? The judgment can be an adoption judgment. It can be a parentage judgment. There are multiple ways to get judgments that protect you. For married couples who have a child within their marriage in California, the easiest way to do that is a confirmatory adoption. Some people call it a second parent adoption. It's essentially, there's no hearing, there's no home study required. You just fill out court paperwork, you file it with the court, the judge reviews it, signs it, stamps it, and sends it back, and you have parentage insurance, right? You have your judgment that legally protects you across state lines. My office helps people to handle these very, very regularly. It's also something that if you are feeling very urgent about and strapped on cash in California, I would say it can be done without a lawyer. It's not the easiest thing in the world, but it can be done. And in California, the filing fee is $20. So, or with e-filing, it can be like up to $40. But it's actually very inexpensive, especially if you're DIYing it, to do it. So, so that is the easiest way, is if you are married and you're in California and you have a child within the marriage, you can do that confirmatory adoption. If you were not married at the time of the birth and you get married later, you could do a step parent adoption, which is a different process. There will be a home study and a hearing provided for that. And if you choose not to get married at all, or if you weren't married at the time of birth, there's always the option of a parentage judgment. These are sort of different procedures that all end up getting you a judgment. A confirmatory adoption is usually the simplest and cheapest in California, but you can do a parentage judgment. Some people find it very fun because they get to sue their co-parent, and how often do you really get to serve your co-parent with papers and sue them? So that's, you know, some people enjoy that process because they think it's funny. For the step parent adoption or an independent adoption, if you're either married after the birth or not married at all, there are home studies involved, there are hearings involved, they are more invasive and a little bit more burdensome. And obviously those are all more expensive options. So these are all options though, they're all judgments, they all go through judicial review and get signed by a judicial officer and are entitled to full faith and credit across the United States. And we have a US Supreme Court opinion that was per curiam, meaning it was unanimous. Everybody agreed, from 2016, where there was an adoption by a same-sex couple in Georgia. They moved to Alabama, and Alabama said, we don't want to recognize this. And the Supreme Court said, too bad, full faith and credit. This judgment was validly entered in Georgia, and you have to uphold it in Alabama. So we have precedent that these judgments are protective, and they are very, very important. Also, just, you know, I'm talking about couples. For single parents in California, you could do a parentage judgment to legally recognize you as the sole legal parent of a child. That's something that you kind of have to look at, whether there could be anyone else potentially making a claim to parentage. Like if you live with a partner who is not an intended parent of your child, if you have a known sperm donor who is very involved in your life and involved with the child, there may be reasons to get a parentage judgment that legally protects you as the only parent of the child. And you can also get a judgment of non-parentage for non-donors and things like that. So those are options in California, but those are a little bit more nuanced and probably require more of an individualized assessment based on the family's circumstances. Also, in California, that confirmatory adoption, like I said, very streamlined, very simple, not necessarily as streamlined and simple as in other states. And so if you live in California and you have the opportunity to do it now, I recommend that you do, because it is so simple and streamlined and inexpensive by comparison to other states' procedures. Also, in California, you can do home insemination, you can work with a known donor, you can still do a confirmatory adoption if those things happen. In other states, that might change the calculus in terms of what's available to you to protect yourself. So every state is going to be a little bit different in terms of what you need there. I don't know if we have any parents by surrogacy on the call, but in terms of surrogacy, generally a judgment is baked into the process. And so you will almost guaranteed have a judgment that recognizes the parents in a surrogacy case, with the one exception that I'm aware of being the state of Illinois has an administrative process for surrogacy where you can just put the intended parents on the birth certificate without going through a judgment process. If you went through the administrative process in Illinois, I would recommend you go back and get a judgment. These are things that can still be done after the fact. For most of these cases, I've done confirmatory adoptions for kids who are 16 years old. I've done surrogacy judgments after the children are born. There are, for most of these cases, not time limits on when they can be done.
Amira, we're getting a lot of questions about the difference between an order of parentage and second parent adoption. If you could clarify.
Yeah, so second parent adoption, or what I call confirmatory adoption, order of parentage and parentage judgment, those are the same thing. So for the at least in California, for the confirmatory adoption, that would be in adoptions court. The non-bio parent would petition. For some people, there's reciprocal IVF where we have a gestational parent and a genetic parent. In my cases with those clients, I actually will have both petition to adopt the child. It's just the paperwork that you fill out is adoption paperwork. So you'd be adopting your child or confirming through an adoption that you're both the legal parents. In a parentage judgment or a court order of parentage, generally the way that that's done is you have a petitioning party and a responding party. I usually have the parent who gave birth as the petitioning party, but it's actually not legally required. It can go either way. That's just the default that I usually do. And the petitioning party will file a petition to establish the parentage of the child. And then you'll have to take those filings and serve the responding party. Doesn't have to be like in the movies where somebody jumps out of the bushes and says, "You've been served." Like, you could just mail the paperwork, or if you live together, as long as somebody other than the petitioner is handing the paperwork to the respondent, that's service. And then you can have the responding party respond and say, "Yep, I agree, I'm the parent," and you file the finalization paperwork with the court, and that gets you a judgment of parentage. In California, a judgment of parentage is on a form that's called FL-250. If you Google FL-250, you'll see what that looks like. The adoption is on a form called Adopt-215. I like to include the 210 with there as well. So they're different forms that look different, and one will be in adoptions court and one will be in family court, but they both get you a judgment at the same time. And court order, court judgment, they're being used. They have very technical nuanced differences that I don't think we need to get into, but they're being used interchangeably in that context. Okay. Does that answer that question?
So you don't necessarily recommend doing both if you've done one?
I don't think you need, I mean, if you want to be like extra careful, you could do both. Like, I know that the former family law director of the National Center for Lesbian Rights did both. I don't know that you necessarily have to, right? Like, I think that that's probably a little bit of overkill, but there may be reasons why one may be better if you have, for example, family abroad, if you plan on living outside the United States. So full faith and credit applies to states within the United States. It doesn't necessarily force other countries to recognize your paperwork. So if you know that you're going to spend an extended period of time in a country where they might not know what a parentage judgment is, but adoption is a pretty universally recognized term, you might prefer to have an adoption versus a parentage judgment in those cases. There might be other countries where adoption has very stringent requirements in order for it to be recognized, and the parentage judgment might be better for you. Generally, in my opinion, the gold standard is the adoption because that is such a universally recognized term, but a parentage judgment should also be recognized and protected in the same way. For some folks, sometimes the judgment is your divorce judgment. Sometimes if you were married to your co-parent and you all got divorced, there may have been a judgment inside of your divorce that said these are the legal parents of the child. That's a judgment too. That will also do the trick. I would look at that language and make sure it's clear there. But as long as you have clear language of these are the two legal parents of the child, that also is a judgment that should be entitled to full faith and credit. So there's kind of different ways to get to the same thing. I was also going to talk very briefly about a voluntary declaration of parentage. This is something that if you have zero other options, again, I always recommend the judgment, but if you have zero other options and you need something cheap and easy and fast, in California, 2 parents by assisted reproduction can sign a voluntary declaration of parentage, and the law says that that should be treated as a judgment. Whether that would actually be binding across other states is still an open question in the law. But it's something that, you know, if you don't have any other choices, those are free. In fact, hospitals usually get paid $15. You could go down to California Department of Social Services and fill one out today. So that's another option. And if you want to do a voluntary declaration of parentage and a judgment, that I think is a very easy belt and suspenders that I don't think is, I mean, again, I don't know that it's necessary, but that one's at least one of them is like really cheap and easy if you're going to do more than one. Okay. I was going to talk a little bit about embryos. So for folks who have genetic material in the freezer, whether it's sperm, eggs, or embryos, I want you to think about what state it's being stored in. Is that a state where there are parentage laws on the book, excuse me, where there are personhood laws on the books that could potentially be putting you at risk for being able to make the decisions that you want to make over what were to happen to the genetic material in the event of death of one person, death of another, or separation of parties if you made, you know, genetic material together. In California, you're required to fill out embryo disposition paperwork with your fertility clinic. That is legally gray as to how enforceable those dispositions in the clinics are. Some people will argue that those are informed consent documents with a fertility clinic, and informed consent, medical consent can be withdrawn. So the agreements in there could potentially be withdrawn. There's an argument that direct embryo disposition agreements between the parties could have a higher likelihood of enforceability than the clinic forms. But nothing is 110% solid there, but certainly the direct agreements between the parties could have a stronger possibility there. I want to make sure there's time for questions, so I'm going to jump a little bit faster through things. I'm going to briefly just mention estate planning. If you have guardianships, powers of attorney, advanced healthcare directives, those are all really helpful to help protect the people in your family. Specifically, I want you to be naming people by name, ideally. So not my spouse or my child, but Jane, Sue, you know, whoever it is, and all these people, if you know who they are not, you know, spouse to be or child to be, put them in there by name. I don't want anybody having any risk of anyone saying, well, who is your spouse really, or who is your child really? If you are trying to have children and you want to be talking about future children, then make sure that you're working with a queer-friendly estate planning attorney who can really write language that is inclusive and make sure that it includes all of your children, no matter how they biologically or legally end up connected to you. If you need gender affirming care, make sure that that is in your advanced healthcare directives, that care continues to be given to you. And especially for guardianships and gender affirming care, you want to make sure that you're leaving people in charge of your children or your own medical care or your children's medical care who will be affirming to your family. We all know that many of us have families who would not necessarily be affirming. And so we want to make sure that we are explicitly excluding folks that we do not want taking over our kids or our medical care if there were to be an emergency situation. And then the last thing I want to briefly touch on, and then I'm just going to leave the whole rest of the time open for questions, is gender affirming care for children. What I would say is in California, there is quite a lot of protection when you have all of the children's legal parents wanting to provide that gender affirming care. But if you have a dispute between parents or, you know, anything like that, you're likely going to be, even in California, on an uphill battle. So document, make sure that you are working with medical professionals and psychological professionals. I know that there are a lot of really great lay resources out there between parents of trans kids and things like that, and those are great to supplement what you're doing. But if you end up in front of a court, you want to show that you are following medical advice and expert advice from medical and psychological professionals, not just what you found on the internet, even if that information is valid and helpful. So make sure that you're keeping track of all of it, that you're keeping your records really clean and clear. And even if both parents are on the same page now, that could change in the future. You know, even if both parents are on the same page, you could end up in a state where that doesn't matter. This morning, the Supreme Court had oral arguments in the Scrimeti case, which is a case over a ban on gender affirming care for minors, an entire statewide ban. So, you know, the state that you live in will have a huge impact on the care that you're able to provide your children. It will likely have an impact on the care you're able to access as an adult. These laws aren't going away. I think they're increasing, and I think that's a place where we're going to see a lot of issues over the next 4 years. So if that affects your family, just do everything you can to document and protect yourselves as much as possible. So I'm going to actually leave the whole rest of the time open for questions.
There are a lot of people, and I'm going to try my best to read your questions, and I apologize if we don't get to it, but I will share Amira's information with everybody after this event. So in the beginning, we had some questions about if someone has a passport and a driver's license that lists their gender as X, what do they do about Social Security?
There's nothing to be done. Social Security won't give you an X, so you pick what feels right for you with Social Security. That's all we can do.
And then another question is if they remove the ability to choose X on their passport, will the current passport with an X still be valid? Can you undo that?
It's a good question. I mean, I think that there's not a definite answer there. My guess would be that the federal government is not organized enough to invalidate passports with X gender markers. And instead what would happen is it will be valid until it expires. And then when it expires, we'll see what the law is then and what you could do.
What about marriages that have been performed abroad?
As long as it was valid where it was entered into, it is still a valid marriage.
Great. Okay. We talked about the judgment and second parent adoption. I think some people, are you thinking that queer families formed over the next 4 years will have a harder time doing second parent adoption or confirmatory adoption? Is that?
That's a really good question. It was actually something I wanted to talk about, so thank you for that one. This is family law in general is dictated by state law, not federal law, on almost all aspects. And so if you live in a protective state, like for example in California, they're not rolling back your rights, they're increasing your rights. We're doing what we can to, you know, boost protections in California. So I think it's going to depend on the state you live in, but you know, for Californians, I want you to rest assured that, you know, what you have available to you now is not going away. If anything, it's going to they're going to try to make it easier. I know I'm working with some lawmakers right now and trying to like reduce the time for gender affirming, you know, for gender changes and legal judgments and those things. If you live in a state that is not LGBTQ LGBTQ friendly, that is where I would have more concerns, and things could get rolled back. And so that's again why I really recommend it to folks who live in a friendly state, like do what you can while you can. And also, as much as the federal government is stressing all of us out, I don't want it to stress you for reasons that you don't need, right? So for a lot of these things, it's really going to be about keeping your eye on the ball on the state law and making sure that that doesn't change to get rolled back and harm families in the states that are not friendly.
Thank you. Is it recommended to get a judgment if you are in a same-sex marriage and have children who are biologically related to both parents? So someone who gave birth using their trans partner's sperm.
I still would. I mean, I think it's one of those things where like it really depends on how people perceive you. If the two of you walk around in this world and you're perceived as a straight couple and people are not noticing anything, then it's possible that you won't be harassed and bothered. But if you have the opportunity and it's not that expensive to get an insurance, I mean, I'm somebody who gets a lot of insurance. And I'm also a lawyer. My job is to think about worst case scenarios. So even though, yes, you are both biological parents, I just wouldn't want to see anybody use any opportunity to try to, deter that in any way.
Can you speak a little bit about the differences between domestic partnership and marriage when it comes to confirmatory adoption?
Oh, yeah, that's a good question. They're totally the same in California. In California, a registered domestic partnership, as long as it's a state registered domestic partnership, has all the same rights and responsibilities as a marriage. At the federal level, registered domestic partnerships are not recognized as marriages. So for Californians who have domestic partnerships but not marriages, in California, it'll be treated just like you're married, but you won't pay federal taxes like a married couple.
Can you talk a little bit about protecting solo parent families?
Yeah, so, like I said, we can do the parentage judgment for a single parent. I think that, the thing about single parents is there's actually, in some respects, a lot more possibility for other people to come in and try to take control because there is a public policy preference for a child to have at least two parents. And so if you have a significant other or a known donor, somebody who is very significantly in the child's life, it's important for you to delineate those roles clearly. There's something in California that says if you take a child into your home and you hold them out as your natural child, you can establish yourself as a parent. And a lot of this case law comes out of straight folks. So there was a case with, an ex-boyfriend and ex-girlfriend who broke up, and the ex-boyfriend wrote to the ex-girlfriend and said, look, you're going to be a great mom. I'll give you my sperm so you can become a single parent. And he donated sperm through a doctor, and she became a parent, and then they were kind of on again, off again. And he made a room in his home for the kid, and the kid started having overnights with him, and he started going on the school forms as the dad, as the medical forms as the dad, and he sued for custody. And she said, no, we both agreed you were a sperm donor. And the court said he might have started as a sperm donor, but he turned himself into a parent by taking a child into his home and holding himself out as a natural child. So if we can get a judgment of non-parentage, that is the best thing we can do to try to prevent somebody from making that claim in the future. So if there's anyone in your life who you think could make that claim, even if now things are fine, then now is a great time to ask them to sign off on something that affirms that they're not a parent of the child and just get that affirmed. And the other thing that I would just take into consideration is for single parent families, it's even that much more important to make sure you have those guardianship and estate planning documents in place, because if heaven forbid something happens to you, you don't have a backup parent there. So you want to make sure that you have your backups in place.
Thank you. If one parent is trans and in the process of changing their middle name, but the first name is the same, should they file, I'm assuming, confirmatory adoption without the middle names of the parents or use the old names?
So names are weird on birth certificates. So I'm gonna back into this question because I want to give a little more background that I think is helpful here. On your child's birth certificate, your name should be your name as it is on your birth certificate, which is a little bit confusing. So historically, it was mom's and dad's, and it was the mom's maiden name and the dad's name, right? That was how it historically worked. And it gets messed up all the time with queer families because even still, it always is that whoever gives birth is listed second on the birth certificate in California, and whoever doesn't give birth is listed first. And so because the first spot was usually the dad's spot, if you're the one who changed your last name, they might not realize that that's not your last name on your birth certificate. Now, it's based on your last name on your birth certificate. The first name, it doesn't specify under California law. The only time when I've seen this as a major issue is when giving citizenship by birth, by descent. My theory is that the immigration authorities line up all the birth certificates of, grandparent, parent, child, grandchild, whatever it is, and they go parent, child, parent, child, parent, child. Great, everything matches. And when they don't match, there becomes a problem. So to go back to your question of your middle name, I would argue that, especially if you're able to update your birth certificate, if you were born in California or a state where you can update your birth certificate to be the name that affirms your gender identity, then whatever name is on your birth certificate is what should go on your child's birth certificate. In terms of the filing with the courts, what I usually recommend is you file under the name that's on your ID, that's your current legal name. but that if you have another name that's on the child's birth certificate, we put an AKA, also known as, or FKA, formerly known as, on that judgment, so that if somebody ever questions you and you have to pull up the judgment, you don't have a judgment that has your name and a birth certificate that has a different name. So you have something to link all of them. You can also, if you have a court-ordered name change, that's also another linking chain. So there's different ways to get to it, but it kind of takes an individualized assessment of, are you updating your birth certificate, and was it changed before the child was born or after, and all these kinds of things to figure out exactly what makes the most sense for each person.
Oh, I wish we had time to answer all of these important questions. So a question on reciprocal IVF, if the parent who carries is adopting, it's fine if the bio parent is listed under the birthing parent, even if they didn't actually birth the baby.
So listed under on the birth certificate, is that what we're talking about?
I'm not sure. Wes, if you want to unmute and clarify, you are welcome to.
Yeah, thank you. In filling out the forms, it asks for the birth parent when you're adopting, and
Mhm.
they are the person who's giving permission to adopt. So in this situation, would the birth parent who's not biologically related, would the biological parent who's not the birthing parent just be put in that spot because they're the one giving permission as the
So when
genetic parent?
I do reciprocal IVF cases, I have both parents adopting and both parents giving permission.
On the same forms?
Yes, although there's one extra form where there's one version for each parent to consent to. There's
Okay.
what's called the AD2 form, which is not part of the California court forms, so it's a little bit confusing. It's a California Department of Social Services form. But that's the consent form, and I have each parent sign that separately, and on the Adopt 200 where it says birth parent, I usually just list the person who gave birth, who physically gave birth, but I think you could list both parents there. I think there's not a right or wrong answer there.
Okay, and just one more question on that. Is it still a step parent adoption in that case?
Were they, as long as you were married at the time that the child was born, it's considered a step parent adoption to confirm parentage.
Okay, thank you.
Mhm.
Thank you. Are adoptions that are performed abroad recognized, or do people need to do the whole process again in the United States?
That's a great question. I would think it would be fine, but I would probably want to look at the individual adoption to just make sure, I'd want to make sure there was jurisdiction wherever the adoption was done and that it was validly done where it was entered into. And if you need a translation, I'd want a certified translation of that just to look at it, but I would think it would probably be fine.
Great. Can you remind us what that resource was for finding queer-friendly family lawyers in other states?
Yeah, it's the Family Law Institute from the National LGBTQ Bar Association. If you search for that, it should pop right up with a map, and then you can just click on your state and find lawyers listed in your state.
Great. Someone asks if my co-parent and I are comfortable with me not being a legal parent of our kid unless my co-parent dies. Is it enough protection to have it put in their will that I will get custody if they die? My co-parent is the birth parent and I am not genetically related.
So I think that there's a really important distinction here between a parent and not a parent. There is no partial parentage. You are either 0% a parent or 100% a parent. So if you're saying this person is my co-parent and we're okay with me not being a parent, well, I'm hearing two different things here. So the two of you need to decide whether you're both the legal parents of your child or you're not. And you need to understand that if the idea is that you only step in if the other parent dies, then you're not a parent and you are completely subject to their whims as to access to that child. If you see yourself as a parent to that child, then I don't recommend that you have something that says that you're only, you would be basically nominated as a guardian and you would be a legal stranger to what sounds like you here as your child. So I think you all need to get on the same page and then act accordingly, basically.
Are there any legal considerations if one kid has a different last name than both of us? My partner is keeping her last name, I'm keeping my last name, and our kid's last name will be a hyphenated version of our last names.
Yeah, I might be biased in this question because my mom and I don't have the same last name. I think it's probably fine. You legally you can name your child whatever you want. They don't have to have a name that's related to you at all. I tell my clients you can name your child Diet Pepsi if you want to, and that's legally allowable. Sometimes people will question it a little bit because it's like, oh, your names don't match, but especially if it's a hyphenate, then it's got both of your names in it. it might logistically, hyphenates sometimes logistically cause problems just because they're long and they're unwieldy, and people don't want to deal with it in the same way that like, Latino double barrel last names can cause problems because we're white heteronormative, and that's what we do. But they're, what I would guess is mostly minor annoyances more than anything else.
Can they legally force single parents by choice to designate another parent for their child or take the child away from a single parent?
In California, I would argue no, although if you are found to be unsafe as a parent, DCFS can get involved for any legal parent who is, found to be abusing or neglecting their child or abandoning their child in some way. It just would mean that if there isn't a second parent on the books, that child could be taken away from you. If you end up on public benefits, that is a place where the Department of Social Services may start trying to find a second parent because they don't want to pay your public benefits, and so they're going to try to put somebody else on the hook. In California, I think the risk there is low. In other states, the risk is higher.
Right.
Mm-hmm.
Okay, sorry, y'all. I'm just sorting through all of
I
these.
can answer a question while you sort that I saw
Great,
in
great.
pop up very quickly.
Great.
There was a question about where to find estate planning lawyers. The Family Law Institute listing does include some folks who do estate planning. And I think there was a question about like, does my estate planning lawyer need to be queer friendly? I think it's really hard to find that person. If I had found them already, they'd probably be my partner. But my firm is looking for that, and we're hoping to have somebody within the next 6 months. But in the meantime, there are a couple of folks out there who are, really LGBTQ competent estate planning lawyers. I think the biggest question is things about like understanding the difference between a registered domestic partnership and a civil union and a marriage and those time boundaries and things like that. Understanding how to incorporate names if people's names and genders have changed, making sure that their definition of parentage encompasses all of that. Are they an estate planning lawyer who thinks to ask you, do you have genetic material in the freezer? Those are people, those don't have to be LGBTQ identified people, but they have to be people who are thinking about those things.
The state our child was born in said they only allowed step-parent adoption, so they went through that process despite being married before the child was born. Now they're in California. Do they need to do another second-parent adoption in California?
No, and don't get hung up on the names. In California, what I call a confirmatory adoption is technically under the step-parent adoption section of the code because it's an adoption within a marriage. So the name, I know people get really nervous about like, I'm not a step-parent. I get that you're not a step-parent. I agree with you. That's why I call it a confirmatory adoption. But on the paperwork, we check the step-parent adoption box. Like, don't stress over that too much.
Okay. Let's see. Yeah, a lot of people are asking about, do you have a resource similar to family building lawyers about estate planning lawyers?
Yeah, so the Family Law Institute.
Okay, I'm sorry, I'm
that listing, yeah.
doing a lot of multitasking.
No worries, I'm starting to look through the chat as well.
Okay. What are residency restrictions for California? If we move there temporarily, is there a time limit on how long we'll need to be there before we can file for a parentage judgment? If we are unmarried, due to give birth in July and considering moving to California?
Let's see, a parentage judgment. That's actually a really good question. That's a little bit nuanced, and I'd have to probably pull up the statute, which is what I'm doing right now. So the question is, are you getting a judgment of parentage or are you getting a judgment? If it's custody in the judgment, then the UCCJEA comes into play, which is the Uniform Child Custody Jurisdiction and Enforcement Act. And then there's a 6-month thing, generally speaking, because you have to be in the child's home state. But if the child was immediately born there and you're living at the time of the child's birth, you can file immediately. You don't have to wait any period of time at that point. So if you're living in California and your child is born in California, then I would say that you have jurisdiction to do a confirmatory adoption here or to do a parentage judgment so long as you're still living here. And a confirmatory adoption can be very quick in California. In LA County, the commissioner who does them is very fast. She usually signs off on it within about a week or two after filing. parentage judgment takes longer. So if you have the option for confirmatory adoption, yes, absolutely. You could move here, live here. You do have to live here. You know, you can't be like visiting your parents. You do need to be living here. But yes, you can do that and it doesn't have to be long, especially if it's just when the baby's born. If it's an older child, then there's a different analysis and we have to talk about that.
Could there be a federal ban on gender affirming care for adults, or is this only decided by states?
Would there be? Yes. Do I think that there would be? No. You know, most medical care is determined on a state-by-state basis. And even if we look at things like, you know, abortion access, it's now still being decided at the state level, but there are things about like people trying to get overturning at the FDA level in terms of mifepristone. So could somebody try to, you know, do something through FDA regulation to, you know, prohibit that or limit that? Yes, but I think that that would be politically really difficult considering the variety of people in this country. And because most gender affirming care also has, you know, other uses, the same medication is used for more than just gender affirming care. I think it would get very complicated. And if you're really curious about that, I'd recommend that you listen to this morning's oral arguments, because I think a lot of that would go towards that question.
So this person commented they need to update ID documents, state and federal, but also need to do a second parent adoption.
Mhm.
Should they wait until IDs have been updated or start on both right away?
Federal ID docs do right away. You can always have an AK or an FK on your paperwork if you have things that are mismatching, or you can use those name and gender change court orders to be that linking chain, but get those federal documents done first, and you can always address the name shifts, you know, through the paperwork that you file through the adoption.
If you're a dual citizen and choosing to live in Europe, can the US government force you to come back to America for any queer family related reason?
I don't think so. That would be crazy. I don't think so. How would they?
Will you all do me a favor? And if you have remaining questions, can you post them again in the chat? Because I've gotten kind of lost in the sea of questions, and I think Amira has answered a lot. So please, let's do another round of putting remaining questions in the chat. I was advised by a student loan financial officer to get a strategic divorce to lower my, whoopsies, my monthly payment significantly. I haven't done this because my queer marriage feels very important, but I'm wondering if there are any legal reasons why staying legally gay married would be important beyond just the normal marriage perks.
I mean, if potentially marriage, it depends on where you live. If you live in California, you're gonna be able to get remarried later if you need to, so I'm not worried about it. And most states don't have a residency requirement to get married, which is why people can go to Vegas and get married. So, you know, if that makes sense financially for you, yeah, you would lose all the rights and benefits of marriage, as you've already acknowledged. But financially, that may be beneficial to you for the time being. And I just don't see a world in which same-sex marriage is not at the very least given back to the states. I don't see a world in which there's a nationwide ban. I would see a potential possibility in the future of losing the protection across the country, but not that everybody would lose the option.
I was never married to my co-parent, and our son was born in a state that doesn't allow for second parent adoption unless we were married. Are there any states I can go to adopt my son?
Yeah, you can do that in California. I mean, you have to, most states have a residency requirement. So it's not like you can just file in another state. You'd have to live there. I have heard that Florida has some pretty, which is bizarre because it's Florida, but has some pretty open jurisdictional rules about adoption. So you could talk to a Floridian attorney about that. But you could, yeah, you could move to another state and do an adoption in whatever state would allow that. California would certainly allow for that.
I had my name legally changed. When I request my birth certificate, they included the name change form with my birth certificate. Should I still use my original birth name or the legally changed one on my child's birth certificate?
So the last name is the one that is legally required to be your birth name. The first name, you can use your new name if you'd like to. On your birth certificate, if you have a California birth certificate and you did a name change that was gender related, you can request that they issue you a new original no, you might have to have a gender change to get a new original. So if you just do a name change without any gender change, even if it is to conform with gender identity, you probably will end up with that 2-page amended birth certificate. But I would say you could use the first name that's your current legal name, and just make sure that the last name is your birth last name.
Any suggestions for how adult gender affirming care language could or should be put in estate planning documents? I know that's not your area of
That's
expertise.
a great question. Yeah, it's not as much my area. I think it would depend on what care you're receiving, right? Everybody gets different care depending upon their dysphoria and what, their bodies and all kinds of things. So I think to the extent that you are already receiving care and you want that specific care to continue, then use that language and say, I want you to continue to make sure that I'm having testosterone or whatever, whatever the case may be. But I would talk to your estate planning lawyer about that as well. That's not something I do regularly.
If my child is most likely trans, they are 6 years old now. Do you recommend we apply for a new passport with a gender change for them now?
It's a great question. I had a conversation with somebody about this earlier this week. It's hard to say because, we know that kids can be gender fluid and we don't know that they are going to, persist in the gender identity that they're in right now, but at that age. And so I think it's a really individual conversation to have, with your co-parent and with the child about, does this feel like where you're staying? And is it, if we make that change, could you live with that for the next potentially 4 years? Because we might not be able to change it back. And if it feels like that's the right choice, then you can make that change. And if it just feels like we're not ready to make that choice, then that's, we're kind of stuck with our options that we have right now. And like I said, I can't guarantee that we're going to lose that option to make the change on federal documents immediate, I suspect that will happen, but I can't guarantee that. And if you live in a state that allows state documents to be changed, you can always update your state documents, even if you can't update the federal ones.
If our baby was born in New Jersey, but we've since moved to California and still need to do a second parent adoption, a cis and a trans masc couple, do we do that in California or do we need to do it in New Jersey?
No, you do it in California where you live.
Great. Do you have any resources for understanding law in non-US countries around recognizing US parentage for queer families?
No. Sorry, the Family Law Institute does have international arms to it. And so if there is a specific country that you are looking for advice on, I can, send referrals to lawyers in other countries who can talk about, that specific information. But I'm not aware of anything, and that doesn't mean it doesn't exist, but I'm not aware of it, of any specific resource about, all other countries recognizing US queer parentage.
We live abroad and our kid was born abroad. As residents in the US, we are curious if you know of any states besides Nevada where non-residents could get a judgment of parentage or a second parent adoption.
So what I said about Nevada is that people can get married in Nevada if they don't live there. So in terms of whether you can get a judgment of parentage or adoption if you don't live there, I think that's going to be really hard to do if you don't live there. It's possible that I think Florida and maybe Washington might have more open jurisdictional laws. I'm working on changing the law in California so that if your child was born here, even if you don't still live here, that you can do a confirmatory adoption here. There are some folks that argue that the law already allows for that. I'm not sure that I'm 100% convinced of that under the law as it's written right now, but I'm still working on my research on that. And hopefully we'll get it just clarified in the law. So if it, you can look to where the child was born to see if there are potential openings to the jurisdictional coverage there. That would be my first place to look. And then if not, then I would look at maybe Florida and Washington State and talk to lawyers in those states.
If I was never married to my co-parent and there's no option for second parent adoption in the state that I live, can I file a custody order? If I can, will that impact my co-parent's ability to adopt another child in the future if there is a custody order in place against them?
I don't think custody orders impact adoption. If you had an order finding that your co-parent was abusive to your child or something like that would be more likely to impact ability to adopt or any sort of criminal history. But getting a custody order, I think would be a smart way to get some sort of legal recognition of your rights to access to your child.
What is the judgment of parentage process like with regards to the home study for a non-traditional polyamorous family?
Yeah, so parentage judgments don't have a home study, which is nice. Adoptions have home studies. The non-confirmatory adoptions have home studies. Parentage judgments do not. For more than two parents, there's something in the law that says you have to make a finding that it would be detrimental to the child to make a finding of two or fewer parents. And so for my families with more than two parents, we write declarations about how all of you have already bonded with the child. You all have a clear established parent-child relationship with the child, that the child could potentially lose, health insurance benefits or a variety of other benefits that are protected by that parent-child relationship. And in general, I've been able to have parentage judgments done without any home study. You can do a third parent adoption, and the difference is in California, you have to show that detriment to the child in the parentage judgment process. And the adoption, as long as whoever the two current legal parents are of the child consent to a third or fourth or fifth parent adopting, then that has to be allowed as long as the home study approves it. So then it's about, what county do you live in, and are you likely to find social workers who are, understanding of your family.
Is there any implication for confirmatory adoption, reciprocal IVF, if I'm a green card holder versus being a US citizen? My wife is a US citizen, but I can't apply for citizenship until next year.
In California, family court does not look at your citizenship, so they should not be related.
Where on forms would you recommend putting AKA or FKA for second parent adoption to recognize we both have taken one of each other's last names, and for trans parent changing a middle name?
At the very least, at the top of the Adopt 200, the Adopt 210, and the Adopt 215. So at the top of the sort of big forms that are filled out, I would put that, you can do it everywhere your name pops up, but it can get a little unwieldy and a little bit hard to write it there. So at the very least, at the top of those three forms is where I would put it.
Great. My partner is trans and got their Italian citizenship prior to transitioning. Now they need to update Italian passport in order for us to get our kids Italian citizenship. Any idea who to ask about this? The Italian consulate is very confusing, and we're not sure how safe they are to ask this to.
I would reach out to Alexander Schuster, who is the sort of the queer family lawyer of Italy that I know of. Italy is not a very LGBTQ friendly space right now. They have criminalized surrogacy for all people who are Italian, no matter where they live. So if your child was born via surrogacy, I would not be looking to get Italian citizen. Well, if you did it already, then you're probably fine. There were also some counties and cities that were taking lesbian parents, like one of the moms, off the birth certificate. So Italy is very county by county specific in terms of how counties might not be the word, but the smaller jurisdictions there have different ways of doing things. But Alexander Schuster would be who I would recommend you reach out to.
If we please keep putting your questions, re-putting them in the chat so that I can make sure. We probably have 5 more minutes. Maybe we can get to 2 or 3 more questions, and then we'll wrap up. Amira, I'm thinking if you're open to this, I think we need to plan another one of these in a few months. And we had so many more people sign up, but there was a 100-person limit on this meeting. So there are going to be a lot of people who appreciate the recording.
I feel like this is a fun speed lightning thing.
Yeah, it is.
Entertaining. I'm oh, I'm gonna stay on my toes for all these questions.
I know you really do. Can you give a cost estimate for doing confirmatory adoption with a lawyer?
I can tell you what my office charges, even though I don't usually publish this information, so you're all getting very lucky right now. As long as everything, and again, there still needs to be an analysis on your individual case to make sure that there's nothing unusual about your case, but as long as you have a typical case, we charge a flat fee of $2,000 for the first child and an extra $1,000 for each additional child after that. I would anticipate that most lawyers charge somewhere between, I've heard as low as $1,500, as high as $3,500 in California. It's going to be different in other states.
Great. Yeah, lots of more questions about the difference between the judgment of parentage or second parent or confirmatory adoption. People are appreciating your expertise. Thank you for sharing it with us. If you're a single parent using a non-known donor through a cryobank, do you still recommend a parentage judgment?
The thing is, it really depends on if you think that there's any possibility of anyone else trying to claim parentage in the future, or if you're planning on living out of state and you think there's any possibility you could end up on public benefits. It would be hard. Who are you going to make the respondent in that case if you like really don't have anybody else? I'm dealing with that with a client right now, but that client has, has disabilities and is worried about, DCFS or someone else trying to get involved. And so they really wanted to make a clear stance that I am the sole legal parent to my child. So we're just kind of talking about like, who are your closest friends who could act in sort of a quasi-parental role, who might be willing to come on as a respondent for you to say this person's not a parent, just so we have somebody else. I think technically you can make your child a respondent, but it gets more complicated if the child's under the age of 12, and it's just, I think it would get unwieldy. It wouldn't be how I would recommend it.
Anything you can think of, Amira, that hasn't been covered in this moment? I think we'll have more information as time goes on about what we're actually dealing with, but
Yeah, I'm just scrolling through the questions as well. I think there are questions about how long it takes to get done. Confirmatory adoption varies from county to county, and LA County is very fast. I've seen as fast as a few days. I've seen as slow as, 6 to 8 months. Usually I would say most counties are in the 2-month range, something like that. I just want to remind folks, I don't think that these are getting rolled back in California. I think, even if we have to push into February, March for these, you're gonna be fine. The only thing that I really think we want to get done before the new administration is getting those federal ID docs updated. But everything else that I'm recommending are insurance policies. And so, they protect you as soon as you get them in place, and the sooner you have them in place, the better. But it's not, a few weeks is unlikely to make or break someone.
great. Can you renew a passport before it expires? If it
Mhm.
expires in a
Yeah.
couple of years, you can renew it whenever you want.
Yep, you can replace, and in fact, you can replace your passport to get your gender updated. And if you're still working on updating your name, if you update your name within a year of getting that new passport, I believe you can get a new passport with a new name without additional cost. So there's just like one form because you just paid for the new passport fee.
Awesome. Okay, well, anything else you're seeing before we wrap up, Amira?
Just scrolling and scrolling. Thank you all for being here. I hope that this was helpful. And I think Maria had asked if my office is accepting new clients, and if you need that information, you're welcome to share my information. We are accepting new clients, but we are also, as you can imagine, extremely busy. So, if you can't get a date to see me until January, that's where we're at right now, unfortunately. But we are happy to help if folks need help.
Everyone who registered will get an email from me either tonight or tomorrow with the recording and some of the resources that Amira mentioned, and her office's contact information, and some more information about the Pregnant Together community, which is a really sweet community of queer folks and solo parents from preconception to trying to conceive and pregnancy and postpartum. And it's so sweet. We have about 250 members now, and excited to keep growing. And we will keep doing these. I saw a lot of comments about how people feel a little calmer and a little safer moving forward with this information. And I think especially for our communities, like, we really need this sort of thing. So we'll do it again. And thank you all for being here, and good luck. Good luck with everything. I hope you have a beautiful evening.